folks, and welcome to the Board of Adjustment meeting for November 25th. Thank you so much for coming. We originally had 3 cases scheduled for tonight. Then the Candy Kitchen case was resolved, so that was not on the calendar. Then there was a case for 1A Lake Avenue, and that was our first, going to be our first hearing tonight. They've asked to continue their hearing. We're going to have to address that. It has to go for a vote before the board. So that'll be addressed first, and then we're going to have one other hearing, and that concerns 240 Rehoboth Avenue. So let's get down to business. First thing is a roll call vote, and we have a full complement tonight. We have Lou Katz, Linda Kaufman, Barry Brandt, and our newest member there, Walt Castle. And I'm Jerry Capone. I'm the chairperson. So we do have a quorum tonight. Ann, would you please advise us how the notices were posted and mailings went out, please?
The agenda was posted on November 18th and amended and reposted on November 21st. It was posted in City Hall and on the portal and sent out to the subscribers.
Okay.
Public notices for the 2 cases that we have tonight were both done at the same time. They were posted on October 31st and sent to Cape Gazette on November 5th and November 8th for posting on those dates. And to Post Press, November 13th, Delaware State News on November 7th and November 8th, and they were also posted at City Hall and on the city portal and sent out to subscribers.
Thank you. Thank you, Matt.
Mailings were sent out to the property owners for each particular case and signage was posted.
So it appears that both cases were properly noticed. Thank you, Madam Clerk. Is there anyone here for the Lake Avenue property? Okay, Mr. Hutt, I see that you're here. Anybody else with you tonight?
I have my client, Mr. Miles, and Mr. Hatton.
Welcome. And has there been any general correspondence received?
The correspondence that was just received this evening was from Doug Warner, requesting his client would like to withdraw the variance application from this evening's agenda.
Okay.
All of the correspondence is specific to the cases.
Then we have to deal with the fact that we have some minutes to review. So the first set of minutes that we need to review and try to approve would be the minutes for March 25th, 2019. Has everyone had a chance to review these? Now, Walt, you're excused, okay? Did everybody have a chance to review the minutes for March 25th?
Yeah.
Yes.
Are there any proposed modifications?
No.
Is there a motion to approve the minutes of March 25th?
I'll make a motion. Approve the minutes of March 25th as written.
Is there a second?
Second.
It's approved. Could I borrow your pen, please?
Sure.
The next set of minutes would be September 23rd, 2019. Have we all had a chance to review those minutes?
Yes.
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 Any proposed modifications?
No.
Is there a motion to accept those minutes?
I'll make the motion.
Second?
Second.
All those in favor?
Aye.
That carries. The minutes are approved. And then we have the minutes of the October 28th meeting. Have we all had a chance to review those minutes?
Yes.
Yes.
Any proposed modifications?
No.
A motion to accept?
I'll make a motion.
I'll second it.
All those in favor?
Aye.
All right, and those minutes are approved.
August 26th.
No, we don't have the August 26th one, is that correct?
Okay. I was just going by the agenda.
Thank you. Here's your pen.
Thank you.
there any old business, Madam Clerk? Okay, then we move to the new business. All right, so tonight we were scheduled to have a hearing, a request for an area variance for 1A located, for Lot 1A located on the corner of East Lake Drive and Prospect Street. And we got a request by mail shortly before the meeting began, requesting that the case be continued. Under the rules, a case that is, where the parties seek to continue the hearing prior to, within 15 days, needs to be approved by the board. So we have to vote on that tonight. As an attorney, people ask for continuances all the time. I don't know whether they provided any reason or rationale for the, but it's frequently, cases need to be continued for one reason or another. And in my line of business, my experience is that the courts normally would agree to a continuance, at least on the very first occasion. I can appreciate that some people may have been inconvenienced coming here to expect to hear that hearing. And I can tell you that I did a considerable amount of work myself in preparation for that hearing. But I would vote for a continuance to allow them to continue. It's a significant project, I believe, that they're planning. And I'd like them to have their day in court, or at least in front of us, and be able to present their case. Are there any other comments from the board members regarding this request?
Yeah,
Go on.
I don't have any problem either, but I will say that we already have 2 cases in December, so the earliest I think we could hear it is January.
Yeah.
I have no problem putting it on in January. That would be fine with me.
But,
Are there any other comments?
but as a matter of procedure, shouldn't we request a reason for it? There may be a very valid reason for asking for the continuance, but to ask for the continuance a few, just right before the meeting with zero reason, I don't think is proper. And I do agree that lots of times these cases get continued, but they should at least give a reason.
Well, I don't know what kind of advice they got. I don't know the gentleman who sent the letter, but I believe that the parties don't live in the area here. So I don't know what the reason is, and I would have preferred that they get a reason. But as I said, as a matter of courtesy, I think that we should entitle them to a continuance. So I'm prepared to vote in that direction, unless somebody convinces me otherwise. Anybody else on this end have anything to say?
No, I would agree.
All right,
Did you have something you were?
Not necessarily. I mean, I think the whole principle that this group has to approve the variance implies that you have the discretion, excuse me, not the variance, the continuance, you have the discretion to deny the request. We don't see a room full of people who are here, a lot of paid professionals who are here to speak to this, so I would think you would be somewhat generous on at least the first occasion, as Mr. Capone indicated. I wouldn't suggest to you that you make part of your motion that you place this on an agenda in any particular month. I don't think they've asked for that, and maybe they're not ready, and they'll have to ask, and we'll have to decide whether it's.
The only thing I'm suggesting is
That it
that.
not be.
That it not be next
December.
month, because we already have 2 cases. So I correct
Right,
that.
and I think that's a good idea, because it could push off other applications that, this was their time, and if we have time in the future, then it's totally good. But you wouldn't want to delay other applicants just because they want to move the date.
all right. So you've heard some people from the board on this. Does the city wish to take a position on the,
We don't have a position whatsoever, and we don't know a reason either for the request.
you're taking no position?
No position.
Is there anyone from the audience who would care to speak about this? Please get up. Now, before you speak, all people who give testimony before the hearing have to be sworn. The Bible right here. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay, then please go back and please tell us your name.
Yes, Frank Cooper, 96 East Lake Drive. I'd like to take issue with your council's open-ended scheduling. I think that really being extremely generous, considering that they stood you up 20 minutes before the occasion, that we now write them carte blanche to have their case held whenever at their convenience. Seems a little extreme to me. I think it should be at your convenience. Linda said January. I think for the convenience of the people who came here too, although we are not paid professionals, we did drive 2.5 hours down and 2.5 hours back for this, so it's not a small deal. And we should be at least given a firm date rather than some nebulous at their convenience. Thank you.
If I could just, perhaps I misinterpreted the response that I thought we didn't get from the audience, that there was anyone in the room that was here for the first application. Right, well, it wasn't it was my impression that there was no one in the room who was here for that purpose, so I apologize if I did not mean to overlook your presence.
We would still have the proper notification, right, in advance?
We could still have, yeah,
Yeah.
you'll get notified in advance. It'll go on an agenda, just like this last. You got notice, believe me. I'm inconvenienced too.
Yeah.
Whenever it's convenient for you, after they stood you up, is a little bit generous.
You know, as things progress, they need a greater and greater reason. Listen, we're all inconvenienced tonight about this. We all did work. We did our due diligence before coming in here. You unfortunately had to drive. Okay. I don't think that our position is carte blanche, but in any event, anybody else want to speak about this request for a continuance? Now, is there a motion then on the request?
I'll make a motion that we grant a continuance for the applicants for Lot 1A, East Lake Drive.
I'll second that.
All those in favor?
Aye.
Aye.
All those opposed? The motion carries. Okay, then we move on to our second case, and that concerns 240 Rehoboth Avenue. Mr. Hutt, would you and your clients like to join us up at the table here, please? Thank you for coming. It's a rehearing, and but before we begin the rehearing, the board has a concern that we'd like to address with the parties, and we'd like your input on this. And I'm going to let the vice chairperson raise the concern for you.
So the concern I have and the question I have for the city is, I'm not really even sure why we're here, based on the fact that let me rephrase that. We granted a rehearing because primarily the notice that was posted on the door that stated that structures or plans submitted prior to September 24th will be reviewed to previous code interpretation. Frankly, I assumed that this would be resolved before we had a hearing, that I thought that they submitted their plans before that date, that they would come in and say, I have my plans before that date, and therefore I fall under the previous code interpretation. So I guess I'm questioning the city why we're even having a hearing on something that is pretty black and white.
Sure. So the notice, and thanks for the question, but the notice that was posted was, there was an oversight, I suppose, that it should have been marked clearly that it applied to residential applications. As you recall, what came out in the hearing that Mr. Robertson attended for 19 Baltimore is that the residential side of building and licensing was interpreting gross floor area one way. The commercial side of the house was interpreting it a different way. You affirmed the interpretation that the commercial side of the house was giving. Therefore, that interpretation was now the law of the city, and the residential side of the house needed to come into compliance with it. So the notice was primarily to let persons with residential applications or bringing residential applications know that the interpretation that was made by the Board of Adjustment would be applied to residential as well as commercial.
But that troubles me even more, because that wasn't necessarily given to us when we decided to have a rehearing. That information was not presented, that it was residential only at the rehearing. When we debated the rehearing, remember, I mean, there's no testimony at a rehearing, and nowhere in the application or the information that we were sent had anything to do with it being an oversight on residential. So we made we made a decision that based on this notice, which didn't clarify, that they had the right to a rehearing because there was more information. But I fully expected that they would take this notice back to the office and say, it doesn't apply to us.
I guess there's another piece of it too, and maybe the building inspector can speak to it some, is that there's a certain, there's I guess I'm looking for a quality of plans. There's different types of submissions. You know, one submission is maybe for a Board of Adjustment application. There's a much more extensive submission for actual building plans. And I'm not sure at what point on the residential side, you know, you viewed an application as being submitted for purposes of being applied under the current interpretation or a different interpretation.
So let me just go a step further. So you're telling me that if I was a commercial property and this sign was on the door, which is still this way, it doesn't say residential, it hasn't been changed, as of at least yesterday when I looked at it. So if I'm a commercial, this doesn't apply to me?
Nothing has changed for commercial. Remember, you affirmed the building official's interpretation. So the way the building official was doing it 6 months ago, you said is the proper way to do it, so he's continuing to do it. And that's what this says, is that the Board of Adjustment's determination will be what's applied. For commercial, it doesn't matter because that's what has been applied. For residential, it matters.
Lou, do you have a question or comment?
When we did what we did the first time around, there was no discussion that there were different ways of doing it. What it was said is, we've always done it this way and we're doing it this way. That is not, we later found out that is not the case. I understand some of it is residential and stuff. So, and I'm one of the people that voted that I agree with the building inspector. Had I had this information, I would have not agreed with the building inspector. Now, I don't think anybody mischievously did this stuff. I think the code is very confusing, but the notion that it's always been one way is not true. And that's what we were voting on when well, that's what I was voting on. So I would agree. I mean, this does need to get cleared up by whatever has to happen with the code, but to hold them to a different standard, I don't think is fair.
Well, the city's view, of course, is that we agree with you that in the 19 Baltimore application, it was demonstrated by Mr. Robertson that at least previous building inspectors had reviewed commercial plans differently than the current building inspector. And I think that was one of the predominant reasons that you voted to let this rehearing go forward, is because that was exposed in the 19 Baltimore application. Part of the motion for re-argument said a finding of fact was that all previous building inspectors had interpreted it one way. Mr. Robertson showed that in fact was not true. So I think we're properly here based upon that new evidence. I'm not sure that it's entirely relevant in the long run to your decision, because the text hasn't changed in the code. So how one previous building inspector determined it, I'm not sure.
I don't agree with that. We heard a lot of testimony in the next case about how it's been different ways of things being done. And that was not discussed when we heard this the first time.
Although the different ways was clarified between residential and commercial, so I'm, okay, I mean, I've said my piece.
Sorry?
May I make?
May I
I
ask
was
a
going to
question?
ask you whether you wanted to say something, so.
I think
Yeah,
we'll-
may I ask a question? Does the code differential between residential and commercial in this matter?
Is that
Does
close
it?
to me?
Yeah.
So section 270-4 gives a lot of the definitions. So the definition section is a general section applicable to both residential and commercial. So the definition of floor area, gross is in that section. The definition of floor area ratio is in that section. The definition of wall, which was discussed quite a bit, is in that section. So I don't think that, there are some distinguishing factors later on, whereas, for example, when in a residential application, there's a credit given for an open front porch, but those basic definitions of what is gross floor area,
Residential in that case.
for the gross floor area, for the open front porch, specifically residential, but for the broader discussion of what I think is really at issue here is the definition of gross floor area. It's a generally applicable definition to both residential and commercial.
Walt, do you have anything Barry, do you have anything?
Nothing additional.
Okay, well, I'm going to throw it open to the city then to present your case. Oh, you did have something you wanted to say?
I did, although frankly, the things that have been most troubling to the applicant in this matter were highlighted a moment ago by Ms. Kaufman and then by the last comments by Mr. Cassell. And those are simply two things. One, there's been no information issued by the city that the notice that's been posted on the website by the Building and Licensing Department and the one that's on the office when you walk in, that it differentiates between residential and commercial. That information is something that I think the public is probably hearing for the first time this evening at this Board of Adjustment hearing. The second thing, and this relates directly to the question that you asked a moment ago, and that is that there is no distinction in the code between residential and commercial with respect to these definitions. These definitions, whether it's gross floor area or floor area ratio, they apply regardless of whether you have a residential structure or a commercial structure. And even probably more importantly, I think, is, as you know, you have another similar, virtually a companion case about 19 Baltimore Avenue. In the findings of fact for that case, the 9th finding of fact states, for FAR and GFA calculation purposes, there is no distinction between structures devoted to commercial or residential uses. And so this board has already, again, it's what's in the code, but this board has already, as a finding of fact, confirmed those things. So with those two, again, I'll refer to them as troubling issues, we question, just as Ms. Kaufman has questioned, why we are even here this evening, as it appears as though this application should be treated the same as all of the others that were submitted prior to September 24th of 2019. In addition to that, bear in mind that the building permit was actually issued once. My client simply didn't pick it up at that time, and then there was a rethinking that occurred on that. So again, bearing all those things in mind, those are the issues that trouble my client with respect to this position.
And to be clear, I'm not, there's two different issues in front of me at this point. One is whether that notice allows your client to go ahead and get the permit. The other continues to be the section 27021B1A that talks about the fact that we all affirmed the building inspector made the right decision. So, you know, we've made that decision twice, and we made it unanimously twice, and I'm not sure the notice changes that, and I guess that will be part of the argument that you're going to have to convince us of, because I see them as two different issues. One is, I don't even think you should be here, but if we're going to go through the hearing, then we have to go through the hearing, but we still have to reconcile the fact that by unanimous vote 2 different times, 27021B1A held that we agreed with the building inspector.
But I was part of the unanimous vote, and I don't believe we had all of the information when we did this. I'm not saying anybody else would change their vote, but I would have definitely changed the vote.
Does the city have a presentation to make?
We have a short one. Thank you, Mr. Chairman. The building inspector's report is in your packet. It's a rather lengthy one. He typically reads it all in. I'm not going to do that unless any of you really feel the need for it to be read in. It's dated October 15, 2019, and is on the record. You also heard a lot from both the city and the applicant on August 26, just a few months ago, and so I'm not going to repeat all of those things. I'm going to try and boil it down to what I think is the most poignant points of the city's and the Building and Licensing Department's position. So as we've said in previous hearings, this really comes down to a matter that is purely one of statutory construction. What is to be included in the calculation of gross floor area? That's the question. What is to be included? We've talked about.
What is I'm not hearing the first one.
What is to be included in the calculation of gross floor area? That really is what we've discussed on numerous occasions with both the 19 Baltimore application and this application at 240 Rehoboth Avenue. In both those instances, this board affirmed the interpretation of the building inspector. And the real point of relevance, I think, tonight is that nothing of relevance has changed from those two instances that you've heard. The text of the code is as it was the first time you heard this application, and it is as it was when you heard the 19 Baltimore application. So the text has not changed. The only thing really that has changed is that we learned that one or more previous building inspectors interpreted it differently than the current building official interprets it. And by the way, interpreted it differently than this board now has twice interpreted it. But that's not relative to your interpretation. The fact that somebody else interpreted it one way, what's relevant is the words of the code and how you interpret them today. Twice you've interpreted them to affirm the building official. So really, and you know, Ms. Kaufman got to the point a moment ago, what I think is the most relevant is we've talked about how do you interpret code? And there's only one place in the code that really, I think, can inform your decision that is most relevant. And that is section 270.21B1A, which excludes from gross floor area the first 250 square feet of an open front porch. If these open areas were to be included in gross floor area, there would be no need for that exclusion. So then you couldn't read any meaning into that exclusion, which would create an absurdity. So the only place that I can find in the code that gives an example of these sorts of areas we're talking about, these outdoor horizontal type spaces, open type spaces, is the open front porch, and it excludes a portion of gross floor area from that calculation. If you didn't count those areas, there'd obviously be no need to exclude a portion of that area. So I really think that's the only area of the code that informs your decision. And as you know, in statutory interpretation, you're supposed to give meaning to all the words, if you can give meaning to all the words. And this is the only interpretation that allows you to give meaning to all the words. So again, I'm not going to get into a lot of what the building official got into. That really is boiled down into a nutshell, the position of building and licensing. And for those reasons, we do respectfully request that you affirm the decision of the building inspector as you have twice before.
Mr. Hutt, do you want to make any further comments?
Certainly, I would like to make some further comments. Again, for the record, I think I've been introduced, but my name is David Hutt with Morris James, representing Jack Lingo Asset Management. And as I admitted at the outset, sitting right immediately to my left, your right is Nick Hammonds. He's one of the principals. And then in the second row of the audience is Doug Motley, another one of the principals. For reasons previously stated, and because I believe that as this is a rehearing, the arguments and discussion that occurred at the August hearing are part of the record and don't need to all be repeated or
Don't
rehashed.
forget, though, you know what? We have a member here who was not present at the first hearing. So if you want him to reflect on something that was mentioned at that first hearing, you better articulate it because he didn't get to hear it.
I will certainly, if I think there's something else that I should supplement that with for his benefit, I will certainly do that. But I think the purpose of tonight's hearing is in relation to, particularly obviously, why this board granted the rehearing. And while it may seem unconventional to use the other party's representatives as your own witnesses, my client's three quote-unquote witnesses tonight will be Mayor Paul Coons, City Solicitor Glenn Mandalis, and Mr. Molina, the Chief Building Inspector in the Building and Licensing Office of the city. Of course, I won't be calling them as actual witnesses to give live testimony, but I'll just instead be relying upon the statements that they have made in their capacities as representatives of the city and in one case as an employee of the city.
And who are those three again? Don?
The mayor, Mr. Mandalis, and Mr. Molina. It is my client's position that after hearing the statements that they have made and applying the law to this matter, that the board, it'll basically, essentially under the law, compel the board to find that a railing does not create an exterior wall forming new areas to be considered as part of gross floor area. As was mentioned the first time this matter was heard in August, in this capacity where the board is right now is sitting in a quasi-judicial capacity. And you're not being asked to grant a variance, you're not being asked to weigh the factors for granting a variance and look for exceptional practical difficulties or those types of hardships. Instead, you're being asked to undertake statutory construction. You're being asked to interpret the meaning of a portion of the Rehoboth Beach zoning code. In particular, you're being asked to discuss and decide upon the definition and how it should be applied for 5 words in section 270-floor, which is the definition, 270-4, which is the definition of gross floor area. And those 5 words are the exterior face of the exterior walls. Applying those words to this situation and what the task is in front of the board, the question tonight is whether or not a railing is the exterior face of an exterior wall. And for the benefit of the newest member, at the last hearing, what was gone through by myself was, on behalf of my client, was how the plain meaning of those words would indicate that an exterior railing is not an exterior wall. And we looked at the definitions in online dictionaries. We looked at the definitions within the building code and how the building code would define an exterior wall. And a number of other factors like that were considered. Tonight's application, or presentation rather, on this rehearing is a little different than that, because whether you're legislatively creating an ordinance or a law, whether you're an attorney trying to work on interpreting it, or a judge or a board trying to interpret it as the board is this evening, there are certain basic principles of statutory interpretation that apply. If you look at the materials that I presented to the board, they were added to the electronic docket this afternoon. There are 3 cases that are presented. 2 of them, I believe, I referenced in August. The other one is the one that Mr. Mandalis referenced.
Just interrupt, they were just given to us today?
They were actually sent in November 15th. I think they were added to the electronic docket this
Okay.
afternoon.
You got them.
Yeah, I just wanted to clarify.
The 2 of the cases, and the ones that I referenced in the August hearing, are Supreme Court cases, and the 3rd case, the one that Mr. Mandalis referenced, is a Superior Court case. What I'd like to do at this time is read a short paragraph from the most recent Delaware Supreme Court decision that's included within the materials, and that is Dewey Beach Enterprises, Inc. versus Board of Adjustment of the Town of Dewey Beach. It was decided by the Delaware Supreme Court on July 30th of 2010. And in the exhibit notebook, it was at Exhibit 9 or Tab 9, and on the electronic docket, I'll be reading from page 158 of 161 at the top of the 2nd column. And it's the discussions.
down.
I'm sorry.
So we can find it.
What head note are you reading? Is it in the head notes?
It's actually at the top of the 2nd paragraph, at the top of page 158. There's a series of bracketed numbers in front of it, 2, 3, 4, 5, 6. It's at the top of page 158.
Yeah, sorry, I just want to make sure.
Yeah, they're not numbered, so.
No, there's our,
Only a few pages in from the back of your.
Okay.
If you don't have a numbered version, it's the 4th page in from the back.
1, 2. One more?
Is that your exhibit?
Tab
8,
9?
Tab 8?
It's in 9.
No, that's the Kent County, sorry. Well, I was going on this. I don't have any more.
That's it. There you go. Nope, a little too far.
Okay, got it.
What's after this one here?
There you go.
Okay, there we go.
Dewey Beach.
I mean, I had it in the other one. I just wanted to get it. I read it. Okay, I'm sorry.
No problem. Let's all be on the same page. At the top of the page, again, right after the bracketed numbers that are bold that say 2, 3, 4, 5, 6, the Supreme Court's decision states, "The rules of statutory construction are well settled. They are designed to ascertain and give effect to the intent of the legislators as expressed in the statute. At the outset, the court must determine whether the provision in question is ambiguous. A statute is ambiguous if it is reasonably susceptible of 2 interpretations. If it is unambiguous, no statutory construction is required, and the words in the statute are given their plain meaning. Several rules guide courts in the construction of an ambiguous statute." It goes on from there, but if I could ask you to turn over 2 more pages On the electronic version, it's page 160. And if you don't have an electronic version, it's just the second to last page. And right above on the second column of the decision, right, the last sentence prior to the word conclusion states, finally, to the extent there is any doubt as to the correct interpretation, that doubt must be resolved in favor of the landowner. And that same principle is found within the other Supreme Court case, which was decided 6 months prior to that, which is Chase Alexa LLC versus Kent County Levy Court. I read from the Dewey Beach Board of Adjustment case because it was a Board of Adjustment case and the most recent Supreme Court decision. The rules of statutory construction are found within the case that Mr. Mandelis referenced in the August hearing, the Friends of Paladin versus Newcastle County Board of Adjustment. That case does not talk about when there is an ambiguity that it's interpreted in favor of the landowner. That case does not mention that, but that is in both the Supreme Court cases. And what the Supreme Court case indicated, as I just read, was that the goal of statutory interpretation, what you're being asked to do this evening, is to give effect to the intent of the legislators as expressed in the statute. And what it indicates is that there's an initial threshold decision that needs to be made, and that is whether or not the statutory provision that you're seeking to interpret is ambiguous. If it's not ambiguous, then the plain meaning of the words apply. If it is ambiguous, then it's to be construed as a whole in a way that gives effect to legislative intent and the provisions thereof, and to avoid absurd results. And significantly, as we just read that sentence at the end of the Dewey Beach Enterprises case, if there are two reasonable interpretations of a code, the interpretation that favors the property owner must control. And that's a principle of law, that a zoning statute restricts the free use of land. And essentially the principle there that is reflected in that is if the government's going to restrict the free use of land, which is what all zoning codes do, building codes do the same thing, they must be clear as to what they are undertaking, and it can't be ambiguous. And if it is ambiguous, then it's interpreted in favor of the property owner or the landowner. As was indicated in that Supreme Court analysis, the first level of analysis to be conducted on this is whether or not the code is ambiguous. And remembering that the definition of ambiguity is something that is reasonably susceptible of two interpretations. The three quote-unquote witnesses that I mentioned at the outset of this demonstrate that the statute is ambiguous. The mayor's statements were printed in the Friday, October 11th edition of the Cape Gazette, which you can find at tab 3 of your the exhibits that were provided. If you have the electronic version, the Cape Gazette front page as well as the article are pages 86 and 87 of that electronic packet. If you just have a hard copy, it's tab 3. But the title of the article is Rehoboth to Review Calculation of Gross Floor Area. And then in large letters right below that, it says Coons, code is ambiguous, should be addressed. And within the body of the article, it states that in an interview, October 10th, Coons said the code is ambiguous, which should be addressed. At the second acknowledgement of the ambiguity of the code is Mr. Mandela's statement during the August hearing on this matter. As the city knows, the video of this is available online through the civic portal. And then while I am not a court reporter, neither is anybody on my staff, we did make an attempt to play court reporters one afternoon, and we took an excerpt from the statements from the August hearing. And if you look at tab 4, which is page 89, if you have the electronic packet, there is an excerpt of some of the comments that were made by Mr. Mandelis. Right in the middle of that, the two paragraphs, Mr. Mandelis states, So that court said, and actually he's referring to the Friends of Paladin versus Newcastle County Board of Adjustment case, which is tab 7 in your exhibits. So that court said the statute is ambiguous when it is reasonably susceptible to different conclusions or interpretations, which I think is the conversation we are having right now. It is reasonably susceptible to different conclusions or interpretations. The third statement is, of course, I think what brings us here tonight, what caused this board to grant the rehearing, and this is probably the most important statement, and that is the statement from, whether it's Mr. Molina himself or from the Building and Licensing Department as a department, it remains unclear. But on September 24th, the Building and Licensing Department posted here in the city, as well as the city's webpage, the notice that was included in the motion for rehearing. I think everyone's familiar with it, but it is tab 2 in the exhibits that were presented by the applicant in this rehearing. And if you're looking at the electronic packet, it would be page 84 is a color version of that notice. And the very last sentence of that notice states that plans submitted prior to September 24th, 2019 will be reviewed to previous code interpretation. It is my client's hope that hearing from these three people helps confirm that the definition of gross floor area is ambiguous. If you agree with the city's mayor, the city solicitor, and the chief building inspector or his office, then the question tonight is whether it is a reasonable interpretation that a railed deck area does not create a new area for calculation for gross floor area. We know that this is a reasonable interpretation because it's the prior interpretation that's referenced in the very notice that the city sent on this issue. So the city's Building and Licensing Office posts a notice that directly states that there was a prior code interpretation through which plans were evaluated and reviewed. Significantly, I think to that effect was an argument raised by Mr. Robertson at the hearing on 19 Baltimore Avenue, where Mr. Robertson walked through a series of properties and presented photographs in addition to the plans as they were approved by building officials. And for the benefit of anybody who wasn't here or does not recall each of those, I've included a copy of the PowerPoint presentation from Mr. Robertson in the materials that I submitted. They were at tab, or are at tab 6 in the exhibits that were presented, and that's pages 108 to 139 of the electronic packet as it's posted online. As I stated at the outset, at the August hearing, my client's primary argument was that the code was not ambiguous. And as you recall, if the code's not ambiguous, it's the plain meaning that controls. And my primary argument at that time was that the plain meaning of this, as it had been previously interpreted by the city, was that the areas within this railing should not be counted towards gross floor area. I haven't spent too much time on that, even for the benefit of the new member, because the primary argument tonight and the reason for the rehearing, the reason it was granted by this board, relates to the notice that was published by the city, which was an alternative argument that was raised in August, but certainly has been changed by the posting of the notice, the statement from the mayor. Those are things that changed since the last time this was heard. But even at the last hearing, I said in the alternative, even assuming that the plain meaning shouldn't control, if the code is ambiguous, it should be construed in favor of the landowner pursuant to established Delaware law. As I understand it, the rehearing was largely granted because of the new information in the form of that notice that was posted by the Building and Licensing Department, expressly conceding that there was a prior interpretation. And of course, if there's another interpretation that the city has used, that code is ambiguous as a matter of law. In addition, of course, you have the comments of the mayor of the city as well as the city solicitor that confirm that this provision of the code is ambiguous. For all of these reasons, my client would ask this evening that the board find that one of the reasonable interpretations of the zoning code is that a railing does not create an exterior wall, area, and therefore the area within that railing is not part of the calculation of the gross floor area. Myself and my clients are certainly available for any questions any members of the board may have.
I do have some questions.
And I have a slew.
So let me, if you don't mind, I'm going to take a few minutes here.
Yep.
First of all, I find, by way of analogy, I find physics confusing, but I'm sure that it's, to some people, it's very clear and unambiguous. So I think there's a difference between confusion and ambiguity. But I want to start off by trying to, I don't know how this is going to shake out tonight, but I'd like to have a complete record. So in the event that it does have to be reviewed by a court, I'd like the court to have the benefit of all the terminology that may or may not be pertinent to the issue tonight. And let's talk about the hierarchy of pertinent terms. Would you agree with me that structure, the word structure, as it's defined in the code, is the broadest zoning term that we are dealing with this evening? Structure, as opposed to building. Is a building a type of structure under the code? And I'm addressing this to you, Mr. Hutt.
I'd have to, I'm trying to turn to the definitions of those terms. If you're going to, if that's what the definition said, I mean, it is what is defined in the code. So-
Well, but building is not used as part of the definition of structure, but, so that's not entirely clear, it's not crystal clear that a building is a structure, but I think we'd have to look at the code and say, a building is a form of is one type of structure. Because under the term structure, it's 270-4. Do you see what I'm talking about?
I see the word building.
Okay, and if you look at structure, the term building is not included in the term structure, but structure does include items such as patios, porches, balconies, and decks. Do you see that? Would you agree with me on that?
I see the definitions of the word building and structure.
Okay.
And they state what's set forth in their terms. I don't know that one's broader or narrower than the other. They complement each other.
All right, but would you agree that a building fits within the definition of structure?
The definition of a building is a structure.
Okay, so, but it's not included in the structure, so a building would be a structure. Let me approach it another way. Would you agree that all structures are not buildings?
Yes, I think that's a fair statement.
Okay. Turning to gross floor area. So we come to the term gross floor area, and it's defined in 270-4 as the sum of the gross horizontal areas of a building measured from the exterior face of the exterior walls. You agree with me that that's the definition?
Yes, that is.
Okay. That definition uses the term building and never uses the term structure. Agreed?
That is correct. I haven't read through the various things that follow that, but yes, that first sentence does not use the word structure.
So that's the definition of gross floor area in the definitional section. Would you agree with me that that would be the general definition of gross floor area?
Is there some distinction between a general? I'm not sure that.
Well, let me parse this further. When we consider the term floor area ratio has its own definition under section 270-4, right? Correct?
Yes.
And that is the quotient obtained by dividing the gross floor area of all buildings on a lot by the gross lot area. Correct?
Yes, that's the definition as it's in the code.
So the word structure is never mentioned in that definition of gross floor area, of floor area ratio, is it?
Correct. There is no mention in the definition you just read of that.
So under that definition, a more narrow class of important buildings is defined as opposed to structures. So we're not talking there about structures, but we're talking about buildings, correct?
It says of all the buildings,
Right.
yes.
But then we move to 270.21, which the FAR is defined, and that's defined differently. Under that section, to calculate the floor area ratio of a commercial zone, you need to calculate in the floor area of all buildings or structures. You see that?
Which section are you reading from?
270.21.
And what portion are you reading?
Under, I think it's A.
Got it right here.
It's the commercial section. It says, under that section, to calculate,
5,
5, yeah.
yeah, 270.
270.21.5,
E5.
B5, sorry.
D.
And I'm sorry, the question again was?
So you would agree with me that there, it's defined as you need to calculate the floor area of all buildings or structures.
Right, it says in all commercial districts, the floor area ratio for all buildings or structures shall not exceed 2.0.
Right, so it's buildings or structures. So we're not talking about buildings exclusively there. We're talking about buildings or structures. Now, one of the problems, and you know, a structure doesn't have to be a building. A structure could be a deck. Structure could be a stairway.
Swimming pool.
Could be a swimming pool, but let's just stick with decks and stairways. So under 270.21 for a commercial building, you need to calculate in the floor area of all buildings or structures. Now, I got to tell you, I got a problem with the word "or" here, because does that "or," is it being used in a conjunctive fashion or disjunctive? And you know what? I'm not picking at nits here. I mean, this is an issue. Is it conjunctive or disjunctive? And if you tell me it's disjunctive, how can it possibly make any sense? Shouldn't we give it the plain meaning of what, shouldn't we try to make sense of the statute here? Shouldn't we? Isn't that a rule of statutory construction, that we try to make sense of something?
Yes.
All right. So if 270.4 says that it's the quotient obtained by dividing the gross floor, strike that. That's for commercial. Now, so we know that balconies and decks are structures because they're included in the definition of structure. Under that interpretation, doesn't a deck attached to a building have to be included in the floor area ratio? Sir?
I don't believe it does.
And why don't you think it does?
Well, first, there's not a floor area ratio question in front of the board right now.
All right.
But beyond that, because the definition of floor area ratio says by dividing the gross floor area, and this is not an area that falls within the gross floor area. It's not within the exterior walls.
But isn't the term defined differently depending on whether we're talking about buildings or structures?
It may be.
Okay. Then I want to point out, I want to ask you about 270-21A, where we're talking about the FAR recalculation in residential districts. Would you agree with me that it's worded there differently than in the commercial district? For example, in residential districts, you need to calculate the floor area for the residence structure combined with accessory structures. So we're not even talking, the term buildings not even used there.
I haven't, in the first little phrase there that is not, I'm not going to make I don't know what falls in the rest of that without reading through it, but.
But nevertheless, don't you think it's clear that a balcony or a deck is at least a structure for calculation of the FAR?
I don't think that that's a clear statement from the code.
Doesn't the code say that 250 square feet of a front porch shall not be included in the gross floor area?
270-21B1A does say that.
Doesn't that clearly imply that other porches get included in the gross floor area of a residential structure?
I don't know what it implies about.
Excuse me?
I don't know what it implies about other residential
Well,
structures.
wouldn't that be a clear implication to you? If it doesn't explicitly say that, wouldn't that be a way to make sense of the code?
It could just be a poorly written provision in a code.
And I got news for you. Well, we agree, it's a poorly provision written of the code, but we're trying to make sense of that. So wouldn't the clear implication be, I mean, I would prefer that it says you only get 250 feet, and the back porch and the side porch, they get included in the calculation. But it doesn't say that. But isn't that the?
It does actually, if I may.
It does say that?
But then the very next sentence says, any square footage in excess of the 250 square feet shall be included in the gross floor area.
Okay. With respect to the
But that was in respect to the front porch,
Right.
right? Okay.
Right, that's a limited statement to a front porch,
Specifically a front
on-
porch.
specifically on floor area ratio. And frankly, I'm not sure how you get to that consideration when the code's ambiguous. The discussion we've just had has, I don't think, it hasn't helped me understand it better, and I don't think that's a deficiency on the questions or the answers. I could be a deficiency in maybe me. But the code is ambiguous. It is difficult to understand, and the law requires a result when that is what the discussion is, and trying to interpret this. And we know that there's another reasonable interpretation out there, which is that they're not included, and the city itself has demonstrated that through many, many years of approving applications.
If this stairway was enclosed, the stairway in question here, if it had been enclosed, would it be included in the gross floor area? If it came down the side of the building and there was a roof on it, would it be included in the gross floor area under your interpretation?
I think that would depend. If there was an exterior wall on the outside of it, yes.
So if it was completely enclosed, it would be included in the gross floor area?
If it was, again, the building code states that an exterior wall is insulated, framed properly, there's certain qualifications that are met. If it met those qualifications, absolutely. It's an exterior wall.
What's the, let me ask you this, what is the relationship between the building code and the zoning code definition of wall?
When you,
Because I don't remember seeing the requirement for insulation in the zoning code definition of wall.
it's not, the problem is when you're trying to, what you were trying to do a moment ago with interpreting all these provisions is you look at the code as a whole, and that wouldn't just be the zoning code. You look at how the entire Rehoboth Beach Code, whether it falls within the zoning code, falls within the building code, falls within the parking and those types of sections, to see if you can ascertain what was the intent of this statute. That's the goal here, is statutory intent. When you look at exterior wall, and you can try to define that term in other ways, and that's why at the August hearing, we looked at some of those ways. We looked at the plain meaning definition. We looked at how does the building code define it. Those things all point to an exterior wall that most people in this room would think of as an exterior wall, the outside of my house, not a railing on a second floor deck.
Right. Let me ask you one more question here. You pointed out that what you're asking for really has nothing to do with the FAR, right? Didn't you
That's
say?
correct.
Right.
It has nothing to do with the application.
You're asking for a relief from 270-29. Isn't the term gross floor area defined differently in 270-29, which deals with off-street parking? Doesn't the term gross floor area, as used in that section, say that that new off-street parking won't be required unless the gross floor area of the structure is increased in size? So there they're talking about the gross floor area of the structure as opposed to the gross floor area of the building. Do you see you see the distinction?
Actually, there's a greater distinction that's drawn, I would argue. It's the existing structure.
The gross floor area of the structure.
The
And
existing structure. That's a key word.
Where does it say the existing structure in there?
This article shall not apply to any existing structure unless 75% or more of the gross floor area of the structure is altered or the gross floor area of the structure is increased in size.
Increase the size. How do you to increase the size of the existing structure, you have to increase the structure. Here,
The existing structure.
well, aren't you increasing the existing structure by adding a stairway attached to the structure on the outside?
Not if there's no exterior walls, and that's the definition of gross floor
But
area.
doesn't the code define structure as a deck or a porch or a balcony? Isn't the structure defined in the code? to include those items?
Those are types of structures, but this is talking about expanding the existing structure. So then you look at what is the definition of gross floor area? And the definition of gross floor area is something you measure from the exterior face of the exterior walls, not something that's by a railing.
Okay, so if we agree, and I think this is the way I'm seeing this, that the structure is the more broad term, and a building can be a type of structure, this particular structure, which happens to be a building, is being expanded by the addition of a stairway and a deck on the outside. And under the particular section you're arguing, 270-29, which deals with off-street parking, you don't get it if the gross floor area of the structure is increased in size. And aren't you adding a structure to this building? A stairway is a structure.
No, we're not adding a new structure. We're expanding the existing structure, but it doesn't apply to gross floor area. The gross floor area doesn't apply by definition.
The gross floor area doesn't apply by definition. Doesn't the term gross floor area, as used in that section, say that new off-street parking won't be required unless the gross floor area of the structure is increased?
Of the existing structure. Right.
You know what?
We're in B, 270-29B.
Here, I got it right here.
I got it right here.
I mean,
Go ahead, you can jump in now.
well, I'm just going to clarify. I mean, it does say that, so if you, simply looked at, if you have an existing structure, and now you're going to change it, then that's where it begins to apply. So you're,
But I would also know, one thing that I think is maybe leading down some of this path of further confusion and ambiguity is that's not the city's argument. If that was the city's argument, we'd have a different appeal here this evening, and we would have had a different appeal in August. They didn't say section 270-29 doesn't apply. The city's position is the existing of the deck on that second floor and then the requisite stairs to get to the ground was an expansion of the gross floor area,
and therefore, the parking was required.
and therefore the additional parking was
So
required.
that is the 270-29.
But the argument wasn't 270-29 doesn't apply because you're adding a new structure.
I have a whole
Or that,
series of
I'm sorry,
questions, but I think-
270-29 doesn't apply at all
I'm done.
to you.
Barry, do you, because I've got a whole series of questions, but
As far as the interpretation, as Jerry walked through 270-4, that was clear to me, it was not ambiguous. You did say that the Delaware Supreme Court said if it was complex and confusing, please, you didn't say that. I mean, you did say that it was about being ambiguous, correct?
I read the Supreme Court decision.
No, afterwards, your commentary. You said ambiguous, and also you have to weigh in favor of your client if it's confusing or complex. Of course it's confusing, of course it's complex.
No,
It's simply about ambiguous, correct?
well, right, if I said that.
Thank you. All
Certainly.
right, that was clear.
Right.
But I got the definition by never leaving 270-4. Jerry walked through building, structure, and if you go to the definition of a wall, I mean, it's the exterior surface of the building, which is a structure. So I don't think it's ambiguous. I mean, in August, I was in favor for you for the variance, for the hardship, but I think the interpretation, in my mind, is clear.
And you would differ from the mayor, the city solicitor, and the
Well,
building.
I'm
I
gonna-
would- I would differ
I'm gonna
from-
address
I would
that.
differ from them.
yeah. And I'll address that. You know, a comment from someone who isn't necessarily an expert, and I'm not going to pick on the mayor so much, but, you know, I don't know that he knows this code inside and out like a lot of us do. So I think we have to be very careful with just because someone used the word, the code's ambiguous. I mean, to Jerry's point, what's the difference between confusion or ambiguous if you're not studying it? So
Well, there's a definition of ambiguity.
I'm being very honest. I'm not putting a lot of weight in the fact that the mayor might have in a newspaper article said, well, the code's ambiguous. I don't know that he knows the code that, to the detail that we do and that the building inspector does. So just hold that thought. The second thing that you said was, statutory ambiguity. And I don't believe that the statute is ambiguous. I think it's very clear. I've said this before. The 27021B1A is very clear. I think there's a difference between the statutory ambiguity and the fact that what's come out of all of this is that you had two people in an office who were dealing with one commercial and one residential, and the person doing the commercial was interpreting it or applying it one way, and the residential was applying it the other. I don't know that that necessarily is a result of ambiguity. I can't speak to that, and I'd like the city to, but it is possible that simply put, one person was dealing with residential that maybe felt it was clearer than the other person. So I still feel that 27021B1A clears this more than what you're trying to argue, and I appreciate trying to reconcile that again. Oh, go ahead. I know you've got a question, and I'll come back to my other.
This discussion, I think, defines, it is ambiguous. I don't think this was deliberate on anybody's part, but we heard at the next hearing when it was at, and I don't remember the dates and stuff, when we were talking about the Baltimore Avenue project, and literally we talked about 22 years of residential projects should now be deemed non-conforming because they were approved and they shouldn't have been approved. If that in itself tells me this is ambiguous, I don't know how this should be corrected, but it does need to be corrected. To me, that's ambiguous. I'm not reading the letter in each of the things, but the people that are enforcing this had very different interpretation. It wasn't one or two cases. It was 22 years worth of cases. They were using different interpretations. That should not be the case.
I don't recall
No,
conversation of 20.
they were talking about all these things. He sat here and said that the residential properties were using a totally different standard when they shouldn't have been using them, and now they should be non-conforming. That's not saying we're making people.
Who said that?
The building inspector sitting right in here in the meeting. Not in the meeting when yours was first heard, and that's why I think this whole thing needs to be cleared up. I think it is very ambiguous. I don't think it was deliberate on any part, but there were very different interpretations by the people who were charged with enforcing the rules of Rehoboth. So in my opinion, because of that, I think it does need to get cleared up, and I don't think we can clear this up live in this meeting. And my whole point is because of this confusion and because of the notice that went out, I think we should grant them to go forward. But that doesn't mean that we don't need to get this cleared up. It's not going to get cleared up by the live in this meeting, in my opinion.
If I can address Lou, Jerry, please. Lou, yes, the conversation of non-conforming did come up. I do not remember the exact words, but it would state it would make these, but the city said, no, they are not taking it down the path of being non-conforming. I think it was a discussion about it could, but they would not.
Well, no,
But the prob-
it doesn't matter. He's
Okay.
saying it shouldn't have been approved, and he did not look at these things. He said he only looks at the commercial. He never looked at the residential. It is confusing, and I think it does need to get cleared up so we don't have these discussions in the future. I don't think anybody, this was not this grand plan to cause this confusion. And even this discussion that we're having here, it's a very detailed discussion, and it's hard to live. This needs to be thought through. And I think there needs to be this part of the code does need to be looked at and needs to be voted on by the commissioners so that we don't have this confusion in the future.
Jerry, may I? Yes. Okay. And I tend to agree with you, Lou, on this. We mentioned earlier about the 250 square feet being excluded at front porch, and that was excluded. But here's my question. Did the city approve plans where they excluded the 250 for the porch, but didn't exclude an exterior deck that had railings in the calculation of the floor area?
What?
So, no, we were mentioned that the
Yes.
code is clear. We have 250 square feet exclusion for a residential, and that's the only exclusion where rear deck is an exclusion. But did the city approve plans?
So I get the
Where-
gist of your
where-
question.
Yeah.
I can't speak for other inspectors. I don't know what they've
Well, I think some of these examples they provide here probably does.
These are from older inspectors, and they're not necessarily
No,
my
but
interpretations.
I'm just asking, has the city in the past, when I remember when the 250 square foot was passed and everything, and it was excluded, but there were properties and homes built that got the 250 exclusion, but were allowed a rear porch or rear balcony on the second floor with railings, and the railings wasn't considered an exterior wall and included in the calculation.
That's what the examples from Mr. Robertson demonstrate.
That's what the
Yes.
examples is. And I don't think it's any error at all. I mean, it's interpretation. I also, it is an interpretation. I don't remember seeing any public notice or any type of hearing on whether it should be included or not included. It was an interpretation, but nothing in public was discussed about it. But, I'm just trying to get understand here, but it seems to me possibly the commissioners should be the ones to look at the code and make clear of its intent. Because looking at this, I mean, we've done things in the past that allowed it, but all of a sudden we don't. It's just, why now when we had history or precedence in the back that it was allowed? So it isn't clear, and I was pretty much elaborating what you said, Lou.
I mean, historically, for the record, and I appreciate, and some of this may be just kind of a historical look. Every building inspector has looked at different things differently, and I think we've talked about that. I mean, that's not uncommon necessarily that's happened. Is that correct, Glenn?
I think that's correct, yes.
So I think the question in front of us, I mean, we're getting, I think, caught up in a little bit of a lot of weeds here. And I mean, the bottom line is, what we're having a hearing on is, did the building inspector interpret the code correctly for this property? It's not, how did somebody else interpret another code 5 years ago, or 2 years ago, or 2 months ago? Is his interpretation for this particular case in front of us interpret the code correctly? And I want to make sure that that's what we're looking at. And yes, I think the city has admitted that there were some mistakes in calculations. That's, human errors. I think different building inspectors, I mean, I can go back to 3 different building inspectors, 3 building inspectors ago that interpreted something one way, the next person comes in and decides on something else, because code is, at best, when you've got a book this thick, you're always going to have some. So I think we have to be careful that we're not judging our decision tonight based on mistakes that may have been made or different interpretations in the past, but is it clear, and did he act, I mean, did he make a decision, did we agree with the decision that he made? The question, I think, that has to get resolved is the ambiguity, and I'm going to go back to what I said. is it statutory ambiguity, which I don't believe it is, I think the statute's clear, or is it two different people looking at something and maybe making different decisions? And to your point, you know, you talked to, and I think the Dewey case talks about statutory ambiguity. So I don't see the statutory ambiguity here.
Very clarifying, and tonight's vote, are we doing the 2 votes again?
We're gonna, somebody's gonna have to make a motion, and then we'll
What do you mean two votes?
we'll decide what that motion is. This can be resolved with any way, with one motion or two if we need to. But I don't think we're finished discussing.
I agree. I just want to know whether, you know.
What do you mean by two votes?
Well, at the first meeting, we had 2.
Well, there's no
votes.
variance on the
They're
table.
not asking for the variance.
Thank you. That's why I wanted to get clear. Thank you.
That's what I thought he was asking.
In response to your comment that maybe the commissioners need to revisit this,
Yeah.
that possibly, but I got to tell you that, you know, Mr. Hutt has given us 3 cases where the Supreme Court in 2 of those cases have had to address issues of statutory construction. And lawyers can labor and toil and study legislation and think that they've done a great job and a comprehensive job. And then somebody like Mr. Hutt or Mr. Mandalis can spot issues. I can tell you that I think there are always going to be issues regarding legislation. Some legislation is better written than others, but I don't think that throwing this back to the commissioners is necessarily the way to solve all the problems. It would be nice to think it could happen, but there are always going to be issues with the way statutes are drafted.
Who's responsible to make it clear on its intent? Who's responsible to make it clear of its intent? I mean, where do you take it to? I'm being new here.
I mean, well, we're here to try to divine the intent. It's our job.
That's our job.
But we're gonna do it live?
That's what our job is, Lou. That's
I don't
what-
think you can do this live and asking these very detailed
But
questions.
you know what? Let me say this to you. This is very difficult for us because if we were a court, we could hear these arguments. 5 judges here, like the Delaware Supreme Court, we could hear these arguments and read your briefs, and then we say, all right, gentlemen, you'll be hearing from us, and we get off the bench, and we'd be able to go back to the back room and discuss these things and talk to our clerks and review the briefs again, do some more independent research. And then in 3 or 4 months' time, we could give you a reasoned opinion that we'd all had the chance to check and review and fine tune. We don't have that luxury. We've got to do this in front of you with very complicated subjects. This is a very difficult way for us to do business. I would like to be able to get off the bench and say, Counsel, what'd you think? Linda, I got a question for you on that. But we have to do it here. And it's tough. It's tough to do. So we have a tough job. But I'm not saying that we couldn't do it better if we had more time. I think we probably could, but this is what we're stuck with.
Can I address the cases and some of the statutory construction issues that have been raised? So let me start where Mr. Hutt started, which is the last case, the Dewey Beach Enterprises case. And he read from, I guess, the 1, 2, 3, 4th to the last page, where it has those 2, 3, 4, 5, 6 at the beginning of it. It says there that the rules of statutory construction are well settled. They are designed to ascertain and give effect to the intent of the legislators. So giving effect to the intent of the legislators is important as expressed in the statute. He went on to read, I'm skipping the sentence, and say that a statute is ambiguous if it is reasonably susceptible to 2 interpretations. If it is ambiguous, no statutory construction is required, and the words in the statute shall be given their plain meaning. I think he stopped around there. But then if you move down a little bit further, this court quotes another Delaware Supreme Court case. And I think this is the relevant, so about halfway through that paragraph where you see the bolded number 308, it says, additionally, words in a statute should not be construed as surplusage if there is reasonable construction which will give them meaning, and courts must ascribe a purpose to the use of statutory language if reasonably possible. And that goes to what the chair was trying to do to describe some of these statutes that use both the word structure and building. And for example, my example about the open front porch, what this court is saying is that you can't read those out of the code. If you can find a way to give meaning to them, both the word building and structure, and both this idea of a exemption for open front porches, then you have to read the statute in a way that gives meaning to them. And if it gives meaning to it, then it isn't an ambiguous statute. Let's turning back now to the second case that is in the packet, which is the Chase Alexa case. And this again is on, so it's behind tab 8 at page 1, 2, 3, the fourth page. The bottom of the left-hand column again has those bolded and bracketed number 2, 3, 4, 5. And again, they say the rules of statutory construction are designed to ascertain and give effect to the intent of the legislators as expressed in the statute. And then if you skip a couple of sentences, and here's the point that Ms. Kaufman and I guess others were making, it says, the fact that the parties disagree about the meaning of the statute does not create ambiguity. So you can have a disagreement, and there is a disagreement here, and apparently there's been disagreements between previous building officials. But even this court goes on to say, if you go down to the bracketed number 6 in that second column, bracketed number 6 and number 7, it says, read any other way, the statute would not make sense. If all applicants have to comply with current laws, then the last phrase of the statute and the project must meet current standards is surplusage. So in this case, they had a statute that said this phrase, and this project must meet all current standards. Just like in our code, we have a phrase that says there's an exclusion for open front porches. And we have a phrase that talks about structures or buildings or structures. Here, they go on to say, words in the statute should not be construed as surplusage if there is reasonable construction which will give them meaning, and courts must ascribe a purpose to the use of statutory language if reasonably possible. So if it's reasonably possible to give meaning to words in the statute, a court has to do that. So here, the Building and Licensing Department is saying is, you can only read the statute in a way that every word is given meaning by understanding that you give an exclusion to outdoor open porches. You have to give meaning to both the word buildings or structure, as the chair was saying. So these rules of statutory construction say, look for the way that you can read the statute, that every word means something, that there's no surplusage. If you're between two determinations or two interpretations, and one of them requires you to create surplusage and read something out of the statute, that's the wrong way to do it. Read it in a way that everything has meaning. And so I think when you read these statutes on a whole, the only way that you can read it is the way the current building official has interpreted it.
I apologize. I thought I had it on.
Anybody else from the panel have anything to add?
I'm just, Walton, some of this is for your education, I guess, or whatever, jumping into this. So, our job up here is to determine one thing, and that is, did the building inspector make the right decision? I think there's been a lot of confusion around internal policies of the city. Notices going up, maybe it wasn't clear, things were missed, but at the end of this, and Lou, I appreciate that, you're concerned that we have to do this live, but that's what you're appointed to, that's what we do. I mean, that's what we do, is we listen to this and we have to make these decisions. But from the standpoint of the finality, no matter what we decide, if we decide against today, then there's still the ability to take it further. And, I'm not suggesting that, everybody should go to court, but the courts could ultimately decide this if we sit here today and decide that we can't do it. So there are remedial ways that this can get resolved if.
We're making an effort here.
I
do the
agree.
best we can to divine the intent here, and I think it's possible to be done. But of course, courts do exist to.
Again, I apologize, I don't know how much you know about the history. I'm just making sure that he understood that there, what we do can always be appealed.
No, I understand that, but some of the discussion we had when we started mentioning there was ambiguity in what we were discussing. That was my comment. And as we were discussing it, and you're saying, well, the 250 square foot, and said that's specifically there, but it hasn't been consistently applied. for a long time, even until September 25th, whenever that date was. So anyway, that was my point.
So that's not
I understand, but,
a problem.
yeah, yeah.
As I said at the beginning, I didn't know where this is gonna go from here. I don't know how this vote, I don't even know what we're gonna vote on for the moment, but I don't know how the vote's gonna go. But I wanted to try to provide a clear record here of everything that might be, all the terminology that might apply to this issue. I think that we've accomplished that much. Now, I don't want to cut anybody short. If you have anything else you want to say, that's fine. I am going to open up the floor to the spectators to see if they'd like to join us. Mr. Hutt, do you have anything else?
Certainly. I wanted to return to, there seems to be, somehow we've created some question about what the word ambiguity means here this evening, and there shouldn't be. The question is, what, under Delaware law, very well established, is whether or not it's reasonably susceptible of different interpretations. And clearly this is. We have building officials, whether it's Mr. Janis, who's sitting here, Mr. Molina, their predecessors have interpreted this in different ways. The statute is subject, reasonably susceptible of different interpretations. So if I misspoke, Mr. Brandt, let's clear the record up right now. Ambiguity under the Delaware Supreme Court is a statute that is reasonably susceptible of different interpretations. The Building and Licensing Office knows this code better than probably anybody in this room. They deal with it more often than the board members, more often than myself, more often than, I don't want to speak for everybody in the audience, but probably just Mr. Janis is probably in the code more often than just about anybody else in this room, I would suspect. And so that office, that's their job, and they have interpreted this in different fashions. They admit they interpret it. They posted a notice saying they interpret it. It doesn't, to me, it doesn't matter whether or not the mayor is law-trained or not well law-trained. That's irrelevant. He's come out and said the code is ambiguous because there's these different interpretations that people are battling through. Residential, commercial, it doesn't matter. The point earlier, Ms. Kaufman, you mentioned that there was this open front porch. The problem is they were excluding, if that was actually clear, why are they excluding 250 of the front porch and not even counting the deck on the second floor at all in those applications? Because it's apparently reasonably susceptible to at least two interpretations. I think the final point of that is, on this application, it was granted a building permit with the deck. Then it was reinterpreted. Set aside the larger forest here, let's look at the tree. In this application, it was susceptible to different interpretations. That's the record in this case. And so if it's reasonably susceptible of different interpretations, we could be here for a very long time. We could miss the Thanksgiving holiday if we wanted to, trying to figure out what all of these code provisions mean. But the law says if that's the case, you find in favor of the property owner, and hopefully it is some sort of a notice to the mayor and commissioners that this issue should be clarified. But maybe they don't want it to be clarified. We don't know. That's their purview. But that's the status of the law on this application.
Is there anyone from the gallery who'd like to join us tonight and make some comments? Nobody wants,
Not touching that one.
yeah, nobody wants to touch this one. Well, you know what, there were mistakes and there's confusion, but I see the hand raised. Again, we're going to ask you, all people to swear on the Bible or testify. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Please stand by the microphone and identify yourself, please.
My name is Richard Perry, 46 Pennsylvania Avenue. I'd just like to point out a factual matter here. And first, I also want to say that these are my personal views. I am the chair of the Planning Commission. These do not represent the views of the Planning Commission. I believe that there's some undue reliance being placed on the front porch exclusion. And if we think back to 2015 and understand and look at the circumstances under which that exclusion was thrown in to the code at the very last minute at the public hearing, when a commissioner realized and said, oh, have we just lost our front porch? There was no debate about gross floor area, what it meant to exclude the 250 square feet at that time. It was to preserve a unique character in the city. That was very clear. It was not debated. It was put in at the last minute. And so I think over-relying on that as an exclusion is just simply, incorrect in my view. Thank you.
Could I appreciate that comment. However, I don't know how much any ways that things get into the code matters as far as interpreting the code. So whether it was thrown in at the last minute or not, it's still, in my mind, something in the code that's pretty clear.
I would agree. I keep pushing the button and turning the mic off, and I mean not to do that. I would caution the group not to look beyond the words that are made part of the code and decide whether some of them were adopted after thoughtful consideration versus those that weren't. And I appreciate that Ms. Kaufman appreciated the comments made by the speaker at the same time, so I understand.
If I may take a different position, I think the legislative history is always vitally important to understanding the intent of a statute.
Well, I don't know that we have the legislator here. I mean, we have somebody who was present at the time, but I don't think he voted on that.
Well, yeah, I'm not, legislative history is important. I don't know if what we heard constitutes legislative history.
Well, then we need to go back to not considering, a lot of the city solicitor's comments have been about the legislative history of that.
Well, everything has got its own weight. There's a certain weight to evidence, okay? Some has more than others, and we've listened to everything. We give great weight to some evidence and other evidence not as much. So I think unless there's any more comments from any of the parties or from anybody in the audience, I think we're going to need to entertain a motion here. So who would like to do that?
I would like to entertain a motion of
Would
affirming.
you like to make a motion?
I would like to make a
Then
motion.
go ahead, make a motion. Don't
Ma-
listen.
I would like to make a motion to affirm the building inspector's report.
Okay, and is there a second?
I'll second it. Did you?
So now, we're going to give everybody a chance to vote on that motion, but I ask, when you make the motion, to explain your reasons for either voting for or against the motion. And Walt, I got news for you.
I'm going to go
You're first, all right?
I just want
I'm
to
going to go last because
affirm the building inspector's interpretation,
which is,
which was.
That is my motion, correct. Is that what you're asking? Are you
and
asking?
the interpretation is,
Well, the interpretation is that this constitutes, well, I guess I'm not even,
Constitutes including it in GFA. That's in layperson's
well, I want to be
language.
careful about that, I'm not. We're upholding the building inspectors, and the motion is to,
Let me try this one on. That the decision of the building inspector that the addition of this stairway and deck triggers the requirement for 2 off-street parking spaces.
Yes.
got it.
Two?
Yeah.
All right, so everybody understand the motion? Walt, welcome to the Zoning Board of Adjustment.
Who make the record clear? I'm not sure that it's 1 or 2 parking spaces. I want you to vote on
yeah,
something.
that's
that's-
what I'm trying
Yeah,
to,
yeah,
because
I
one
mean,
thing
the
was,
notice
it was
says
already, a
and-
decision was already made on that, and it's, now we talked about ambiguity, so.
I would
I'm a
just say
little
whether
confused as-
off-street parking is required based upon the addition of this structure, because the notice only says an off-street parking space.
So,
Okay, hold on.
so,
Where's the building inspector's report? Let's clean this up.
Triggers the need for off-street parking. Can we agree that just triggers the need for off-street parking? Take off the 2. 270-29B, which requires off-street parking.
Yeah.
Okay, that's it.
It did say and, so I was incorrect, so, okay.
All right.
Then
So,
it's-
so,
So, let me just, go ahead, ask the question again. Go ahead, what was the,
no, I was just going to say, so what I'm understanding the motion to be is we're affirming the building inspector's interpretation based on 270-29B that would require additional parking.
That the erection of this stairway and deck would trigger the requirements of 270-29B to require off-street parking.
so let me ask a question, just because I'm new to this, and I just want to make sure. So in the prior hearings, you already decided that it is included in the FAR. He's coming to mention it was ambiguous now. That's what they're putting the case on, correct? On the ambiguity.
But that's not what his motion
Okay.
is. His motion is, if we approve this, we would be, again, upholding what the
okay.
building inspector did, and then they can't move forward
Okay,
with it. It's not dealing with the ambiguous issue
okay,
specifically, based off of this motion.
I understand, okay.
I think that's correct, what I just said.
If I thought it was incorrect, I would tell you. I'm dying to hear what Walt's got to say.
Yeah, I just, again, looking at all the facts and looking at the case they brought in front of us, there's inconsistency here. There is, I don't see consistency, and, it's an interpretation, but it's been interpreted differently in the past. So I don't know if I agree with it. I don't agree with it.
Excuse me? Counsel, do you want to chime in here?
Well, I think what the member has said is that he doesn't see consistency in the interpretation, but I think what we'd like you to sum up with is your position on the motion. Do you vote in favor of the motion that,
I don't vote in favor.
so you would go down as a no?
Correct.
And your reasoning is that there are this code provision is susceptible to two different interpretations, and therefore it's ambiguous and has to be interpreted in favor of the applicant.
Okay, it's your turn.
I am voting in favor of the city, and my justification, my reasons for this is everything I needed to understand about this was in 270-4, walking through building structure to the definition of a wall, the vertical exterior surface of a building. A building is a structure. So for those reasons, I am voting in favor of the city.
Lou?
I would not be in favor of it for the reasons that Walt said and what I've said through this. I do not think this was deliberate, but I do think it's ambiguous, and there's been a lot of history of many interpretations of what this code is, and whether we clear it up or somebody else clears it up or how it is, I just think in this case that they should be allowed to go forward. So I would say no.
Ms. Kaufman?
I'm voting in favor of the motion. I'll cite 270-4 with the definitions that I think helped clear it up. Obviously, 270-21B1A that I have stated before. I think there's a clear distinction between statutory ambiguity, which I don't believe is there, and therefore I'm voting in favor of the motion.
All right, and that leaves it to me, and I am going to vote in favor of the motion. My reasoning being that I believe, in accordance with 270-29B, that the stairway and the deck increases the gross floor area of the structure, and therefore that triggers the requirement for off-street parking. So the motion carries. The building inspector's decision has been affirmed. So any other business tonight?
I'm looking for you.
How about a motion to adjourn?
Or just check it. Nope, there's no other business.
Okay, do I have a motion to adjourn?
So moved.
All those in
Second.
favor?
Happy Thanksgiving, guys.
Same to you.
Get rid of